Mr. Morris, I guess I'll start out by saying I'm aware of what you're here this morning. You have filed a motion to vacate judgment of dissolution that was entered in this case on October 20th of 2023. I have reviewed the file in light of your motion and can tell you that the motion was filed because a petition was filed indicating that they essentially dropped off the face of the earth, that they had lost contact with you, and they received, or Candace received what's notice of, leave from the court to provide service by publication. That service by publication was made, and on August 22nd, proof of service by publication was entered, and then the matter was set for prove-up, and a default judgment for dissolution was entered. And your petition really doesn't address any reason why I should vacate that judgment. Moreover, we are all aware here that the petitioner, Candace Morris, passed away on March 26th of this year. And I question why at this time you would want to vacate the judgment of dissolution.
My turn?
Yeah.
Okay, we're on, okay. First of all, the last communication I had from Candy was on June 2022 via email. We had 8 friends on Facebook, including her sister, brother-in-law, and nephews who had my contact information. Our daughter, Denise Morris, had my email, my Facebook, my telephone number, and my address at the time that she filed for divorce. I have verification of that via screenshots and printout proving that she contacted me.
Who?
Yes.
Who contacted you? Put that down, please.
All right,
Who
sorry.
contacted you?
Candy contacted me.
When?
June, let me get the right date. She contacted me on January, February, March 21st, 2022 via Facebook message. And then she contacted me on the 22nd via an email.
Okay, well, this case wasn't even filed until August 20th of 2013, which is more than a year after that.
Well, you mean 2020? That's correct. She did not contact me after that at all, but she still had my contact information, and our daughter had all of my contact information. So she did not.
Sir, I can tell you that the law requires that if a petition for dissolution is filed, that the petitioner, Candace in this case, is required to obtain service on you in accordance with the Illinois Code of Civil Procedure, that letting you know via email or Facebook is not adequate. And having a Facebook page is not in any way gonna satisfy the requirements of the Illinois Code of Civil Procedure. Moreover, you filed on August 19th, 2013, a waiver in consent. And your signature appears on this document, and it is authenticated by a notary. So you had actual notice of this proceeding.
Not of the divorce, of the legal separation.
So what?
We were legally separated.
Once you enter an appearance in this case, all they have to do is mail you notice at whatever address you filed with the clerk. So if you move to the Philippines without telling them or telling the clerk, that's on you, not them.
Okay. I should tell you or inform you that the reason I signed that legal separation is that Candy told me to.
Okay,
Not,
Mr. Morris, you
Yes,
still
sir.
haven't answered my question. Why do you want to vacate? What's your reason for wanting to vacate this judgment? She's deceased.
oh, I know that. I bought her a condominium in 2013. I used my credit and I did almost $70,000 of improvements on that condominium. The reason was, sir, that I was diagnosed as being a submissive partner in a marriage. And I did whatever she wanted me to. She told me to sign, I signed it. She told me to remodel the condominium, I did. And we were legally separated, but then she filed for divorce and did not tell me. I have a financial stake in that condominium that was sold.
Well, as far as I can tell from viewing her obituary and checking the public record, she died intestate and had no assets.
She had a condominium, sir, at 222 Lily Lane in Rockford, Illinois, that sold for $250,000.
Well, sir, she has not, no probate action has been filed in either Winnebago County or Boone County. At the time of her death, she lived in McChesney Park.
The condominium was just sold.
Well, sir,
by
I'm sorry. And I'll tell you the final reason I can't help you. You're telling me about all these diagnoses, and I mean, this is the kind of thing that is gonna require notice to Attorney Belush, who was her attorney in this divorce. Since she's deceased, that's the only place you can send notice. And will require a hearing in person.
I did try asking, or I did ask for the attorney through her power of attorney person and my daughter. Nobody got back to me.
Okay, sir, we can't help you. I can't help you, I'm sorry. For two reasons. One, your petition is untimely. Two, meaning it was filed too long after the fact. And two, because you're gonna need to proceed on this motion with notice, not to the power of attorney, to the attorney in fact, and in person. Because if you're gonna say that all of this was taken from me by subterfuge, you're gonna need to present evidence, and the estate is gonna have to have an opportunity to be heard.
I have asked for who is the attorney, sir. Nobody has
I
contacted me.
just told you, her name is Laura Belush, and she's with Barrett Schweitzer here in, well, their office is in Rockford.
I apologize. We cut out. I am sorry. What was the name that you mentioned?
Laura Belush, Baluch.
I sent her an email also and a voicemail asking her to contact me.
An email is not notice. You have to file a motion and you have to send her a copy of that motion by mail or email, but you actually have to send the motion as attorney for Candace and indicate in your motion that Candace is deceased.
I did give my daughter Denise and Tammy the motions and asked them.
No, sir. I'm trying to explain to you that I cannot help you. You have not complied with the Illinois Code of Civil Procedure, nor have you presented any legal basis for me to vacate the judgment of dissolution entered 2 years ago. All right?
Uh-huh.
And I'm sorry, I cannot give you legal advice. I'm a judge.
I understand that.
I can tell you that you have to comply with the rules of civil procedure as well as with the legal rules that apply to this motion. Okay?
I understand. I will send information to Laura again, and she never got back to me.
Well, she may never get back to you. I can't do anything about that.
I understand.
Because why would she respond? She's not gonna get paid. And
Okay.
even if she doesn't respond, I'm telling you that you're gonna have to come back to Belvedere to present your motion, because I need some evidence and some testimony under oath.
I understand.
Okay?
Yeah.
All right. Good luck to you, Mr. Morris.
Oh, no, I have none. Nobody told me she died. I found out on Facebook.
Well, I still wish you good luck. Okay?
Yeah. Thank you, sir.
What's that? Oh, okay.
Is it in the hall or is it out?
Thank you, Mr. Morris. Number 19, wait, are we waiting for an attorney? Yeah, that's who I'm talking about. You expect him, right?
I haven't spoken. I called his office yesterday, Your Honor, and they didn't respond to my call.
Judge, Tyler's office just called me on my way here. I guess he will be appearing on Zoom.
That's fine.
That he, I guess, had another court case calling.
He contacted you though, not him.
His secretary did.
You need help leaving, Mr. Morris, or you just hanging out watching?
No, sir, I wasn't sure if you were dismissing me.
Oh yeah, we're done for today. Thank you, sir.
All right.